Or maybe I'm not turned on.
You are not turned on.
Okay, I need to do that.
All right, am I on your thing? Coming in?
Don't sound like it.
I don't think it's gonna do anything here.
Okay,
Can you hear me?
you're on.
So that's good?
Mm-hmm.
Well, I'm Bob Bond, and I'm delighted to be here this afternoon and talking to you guys about what to do when someone passes away, or all this the concerns about estate settlement, trust and probate administration, and so forth. So we're going to run through a lot of things this afternoon, and you'll have a chance to ask questions as questions arise. And you all know me, I'm your estate planning attorney, and I've been doing estate planning since I first started practicing law in 1994. So it's been quite a few years. And I'm blessed to have on my staff Stephanie Searcy's been working with me since 1996, and Kathy Durette's been working with me since about 2000, and Mary's been here a number of years. So we have a really great crew that is involved with trust and probate administration, as well as the creation of estate planning documents. And it means we have a lot more ability to help clients where there's that kind of expertise. And of course, you know, we have another segment of our practice, which is the elder law side, which is a lot of times concerned with Medicaid qualification for people that are at the stage where they need nursing home care and don't have many resources. And on that side of the business, Les Berry helps me, and he's been working with me for a number of years, and before that he worked for Medicaid, so he's extremely knowledgeable in the best way to handle that. Now, before I started my law career, I was in the Army for 20 years, and I retired from the Army in 1969. And then I've been blessed to have been married for 50 years this year.
Wow.
And
That's
so
great.
my point of continuity, you all probably been married a long time too, but and we have two children, and we have 7 grandchildren, so we're really blessed on that score. Now, over the years, we've had a chance to help thousands of Texas families protect their loved ones and their wealth, and so that's come to be, I feel like it's my calling, and so we want to be able to help you and your family as well. So thanks for coming today, because this is an important topic. A lot of times people worry about it. Some people worry about it. Some people just hope it'll all work out okay, and some people want to deal with it but just never get around to really addressing the issues. So hopefully I can answer some questions on this. And of course, the reason why we don't do these things is because it's so easy to procrastinate about this kind of stuff. It's not an urgent today to deal with it, and so it's the kind of stuff that's easy to put off. The other thing is lack of knowledge, of course. So that's one of the things we want to address today. So what we want to talk about are the roles that people play in the estate plan, what legal processes are required when someone passes away, and the important steps to take with those deadlines and other activities that need to be done, and then how to start planning for yourself or help someone else. So there's a saying that you can live without an attorney, but you cannot die without one. And there's a lot of truth to that. So what we want to talk about is the importance of planning. We want to talk about what probate is and how to avoid it, and we're going to talk about Bill and Mary and a lot of other people as we go along. And of course, you know we have some refreshments here. If you need to get up and get something, help yourself even while I'm talking, that's fine. The restrooms are around the corner, so did you all find out about that already?
The restrooms are inside or outside around the corner?
You
outside.
go out the door and they're in this hallway right back here.
Okay.
And the ladies, it's 425, and the guys, it's 524. Like dyslexia.
Wait, 425?
For the ladies.
Okay.
524 for the guys.
Okay.
Yeah. Then we'll have a break here before.
Okay.
So when someone passes away, there's a lot of things that require immediate attention. So here's a list of them: providing support to family members, notifying friends and family, funeral arrangements, locating important documents, paying bills and expenses, and finding money immediately if you're suddenly having to settle someone's estate. And so if someone passes away, there's this sense of furious activity, at least for the first few days, and a lot of that is focused on actions the family needs to take to find things or deal with the facts as they are. And then we have a bunch of scenarios about how this is going to develop. Do we have a will? if there's no will or any planning, well, then that's a scenario. There's a living trust, or a trust exists but it's outdated, or assets are held in different forms that go around the estate planning. And so this may work with the estate plan, or it may work against the estate plan. It just depends on the circumstances. Okay. In this estate planning, in the settlement of estates, or in the necessity for action, we have these names for who these people are, and sometimes there's confusion between the will-based planning or a trust-based planning. So the first thing to talk about, and the one that comes right to mind, is with a will, an executor's appointed. Now, an executor might be a beneficiary, but being an executor is not the same as being a beneficiary. The beneficiary gets the benefits, the executor gets the work, okay, and the responsibility. And so these are just two distinct roles. So the executor's job is to settle the estate. Well, what's the difference between an executor and a trustee? None at this stage. It's the same role as far as what you're supposed to safeguard the assets, do what the will or trust says, and you're a fiduciary to carry out the instructions in the will or the trust. And so you say, well, the trustee though could last a long time. What's the difference between does the executor last a long time? Well, that does bring an important area of understanding. And the period of an estate, what is that? Well, legally it's from the time someone passes away until the property is distributed. Okay? Now, let's say that after the parents passed away, the property was going to go into a trust for the kids. Well, when it goes into the trust for the kids, the period of the estate is over. So that's, in other words, you can have the trust continues, but as far as this period of the estate, it's from the date of death until the property moves out of this estate mode into its next stop. That next stop could be a trust for the kids, or it could be outright to the kids, for example. Okay? So that's the period. And you say, well, how does, who's looking at this and what's involved? Well, the first thing to say is that the IRS says that's the period of the estate, and the reason we're interested in it is if there's any income earned during the period of the estate, we want somebody to keep track of this and pay us, right? So there's a tax issue, there's a legal period there as far as the IRS is concerned. Now, as far as the judge, if you're an executor is concerned, an estate could last a long time. So in the case, remember Howard Hughes died, he didn't have a will, and everybody came up with handwritten wills and all that stuff. He died in 1976, I think it was, and his estate was finally settled in 2009. Right? That is not the way we want our estates to work, okay? We want our estates to close. Now, the general rule is estates should close in about 2 years or less. And as a matter of fact, the IRS wants you to explain why it went past 2 years, if it goes past 2 years. But it can if it needs to. But in terms of your own estates, the estates you're dealing with, you want the estate period to end as quickly as possible, because if you're the executor trustee settling it, you want to be done. Right? So what does that involve? It's typically going to be a matter of, if everything's set up correctly, it's going to be a matter of months. Right? So why months? Well, it takes the executor or trustee a while just to get their hands around everything. It's just in the great scheme of things. Also, if the trustee or executor is the surviving spouse, the surviving spouse has a lot of distractions and a lot of grief and other things that kind of slow the process down. And if one of your kids is the trustee or executor, they probably are working full time on other things, and so this has been a huge additional task for them. And getting it done gets stretched out to get it finished. But if things aren't, if things go smoothly, we're really talking a matter of months to get it accomplished. So just for another way to visualize this, if we're talking about a will, it takes about 8 weeks from the time you say, yes, we're gonna submit the application, until we get the letter from the judge that says you can go get the property, okay? So it's gonna take 6 or 8 weeks to get the letter that the executor needs in order to go access the account or access the safety deposit box or to have the power to sell the property. And so that means that if whatever's in probate property is going to be a period of 2 months before they can actually do anything, and then they start whatever they're going to do. So you can see why that would lengthen it out. So it's not going to be, in the typical case, it's going to be more than a couple of months. It might not be too much more than a couple of months to do this. Okay, the testator is the person that wrote the will, and in a trust, it's the trust maker or the trustor or grantor. Those are different words for the same thing. It's the person who created the trust. And a beneficiary, of course, is the one that's going to receive the benefits, and that's the same term in both of them. If someone's disabled, not passed away, but disabled, then you have agents under the power of attorney that would have the duty to and the ability to access financial accounts and other administrative affairs for the disabled person. If you don't have power of attorney, then the only way you can get that control is by guardianship, and we never really want to do this. It's just too much trouble and expense. So we want to make sure we have a power of attorney. Okay. So one of the first things we do when we're talking with clients after they passed away is to determine what property they have and what category it falls into. So the one category is the probate property. If they have probate property, then you're going to have to do a probate. That's the answer in all likelihood. If there's no probate property, then you can skip it. Okay, it's not an issue of if someone has a will, they have to go to court. It's a question of whether you have property that's governed by the will, or you don't have a will and you have property that's probate property. If it's probate property, you get to go to court. Okay, so let's see if I.
Well, putting it in a trust, it's no longer probate property.
Correct. Correct. Yeah, exactly. So your estate consists of a variety of different things. So one thing it consists of is maybe stocks and mutual funds and so forth, and it depends on how those are held, obviously. I mean, depends on how they're held. If they're held in a trust account, well, they're not probate property. If they're held in your name, or they're held in joint name, but it's tenants in common, well, they're probate property. Real estate in Texas, if it's in a trust, it's not probate property. If it's not in a trust, it's probate property in Texas. Cars and trucks in Texas, technically they're probate property, but if that's the only asset that only probate asset that they have, you don't have to go to probate court for cars and trucks and motorhomes in Texas. In some states you do, but not in Texas. And then money, of course, is a probate property if it's in an account in the decedent's name. Right? It's probate. If it's in a trust, it's not. Other types of non-probate assets, life insurance and annuities, if they have a beneficiary designation on them and the beneficiary is alive, then they're not probate property. Joint tenancy with right of survivorship is not probate property. So for people who don't plan their estates and who are married, one of the most common types of property that people have is the husband and wife have a joint checking account. The joint checking account is in all likelihood this joint tenants with right of survivorship. And if it's that, it's not probate, and it means that if one of them passes away, that account belongs to the surviving spouse. So it's not probate property. Also, if you have an IRA with a beneficiary designation on it, or you have an account and you put a they're called pay on death or transfer on death accounts, that's a way of taking an account and turning it into a non-probate asset by putting a pay on death or transfer on death to that person. And we also use it sometimes with accounts that are hard to put in a trust. An example of this would be credit union accounts. Sometimes the credit unions will not allow a trust to be a member of the credit union. So one way we deal with that is by person just stays on the account in their name, but as the trust named as pay on death beneficiary. So sometimes that's the way we set it up. So it's not probate property, and it still works with their overall estate plan. And of course, living trust, the property inside the living trust is not probate property. Now, for most clients, well, in an unplanned estate, the people are going to have probate property, joint accounts with right of survivorship, and beneficiary designations. They're going to have typically have all three of those in many cases. In people who have wills, they're typically going to have all three as well. Okay, and then in trust planning, what the typical arrangement is, if it's set up ideally, then the client won't have any probate property because all the probate property is in the trust. But they will have some accounts that are not in the trust. And remember, the classic example of that is your individual retirement account. It's got to be outside the trust because an IRA can only be in one person's name. That's it. And that one person is whoever set it up. You can't switch it around either while you're alive. So whoever set it up, it's got to stay under their name. And so in order to get it to behave and follow what we're trying to do with our estate planning, then we want the beneficiary designation either to be typically to our kids, or we want it to be to the trust for our kids. But the IRA is outside. So you got the trust, all this stuff is titled in the name of the trust. The IRA, though, is under your name, but the beneficiary may be in the trust. Does that make sense? Okay. Some of you talked about that. Okay, what about all this stuff? All the guns, jewelry, and household items. Technically, they're probate properties, but we put them in the trust. Okay, so if you have a trust, one of the pieces of paper that you signed at the closing was an assignment, and you assigned all of your stuff to the trust. And this is a lot of times people forget this because it's a very simple form, and you don't have to think about it very much because you don't have to list things specifically on it. It just says all of my lawyers call it tangible personal property. I declare that it's part of the trust. And so with that, then if something happens to you, legal control belongs to your trustee, which is exactly what you want. Now, when we're doing will-based planning and trust-based planning in our office, typically the document says, look and see if I left a listing about where I want this property to go. And so a lot of times many times it's stuff of sentimental value. It doesn't necessarily have great value. Sometimes it has great value. But in any event, that property, then you can say, I want my son to have my shotgun, I want my daughter to have my wedding ring, and all that sort of thing on that list. And this is a much more convenient way to keep track of that for your estate planning than to actually write it down into the trust, because those things get out of date and you may want to update and add to them as time goes by. So the trust or will says, look and see if I've left a list about where I want this to go, and if so, trustee or executor follow that. Okay, so probate. How come if somebody creates a will, it's signed, it's witnessed, it's notarized, it's initialed on every page? Why do you have to go see a judge about this thing? And somewhere on the first or second page, it says right there who the executor is. So how come the banks won't accept it? How come the title company won't accept it? Why do we have this rigmarole about having to go to the judge? Well, it's been around a long, long time, and the reason is this: that the bank or financial institution does not know whether that is if you present a will, they don't know if that's the last will and testament or not. Okay. Well, they're not going to guess. They're not going to take your word for it. None of that. Okay. That's just not the way the deal's played. They also don't know whether it might be a forgery. They don't know. So the answer is that a judge has to say, yep, that is the last will and testament. And this person, whoever the executor is, or if there's no executor named, whoever the family court gets put in place to be the administrator, which is the same as the executor, then the judge okays that person, and the okay is to go round up the person's property. Now, technically, the executor works for the judge, And so, or is responsible to the judge for properly carrying out the estate. And what this means is that the trustee, the executor is supposed to round up all the assets, pay all the bills, and then distribute the property the way that the will says. So that's the game. And so that's what this says right there. Now, why would we want to avoid probate? Well, it's going to slow down the process of getting control of the property because, like I said, if it's probate property, you're going to have to wait 8 weeks before you can do something with it. So I don't know if I have a slide somewhere, so I may be picking this up too soon. But this comes up to an important point here that a lot of times people don't think about, or at least not address, and yet if someone passes away, it's immediately a concern. Okay, and so here it is. The question is, how long does it take the executor, trustee, family member to get control of some assets to pay bills, right? Somebody passes away, kaboom. Well, we got to pay for the funeral. How are we going to pay for the funeral? We got to, one of the kids is out of Mongolia or something. We need to give him money to fly back here for the funeral. How are we going to do that? What are we going to get any hotel rooms? Are we going to have a caterer? All that stuff that comes up. How are we going to pay for it? And how soon will we have money? So, if to the extent that major assets are probate property, well, it's 8 weeks is about the best you're going to do. Okay. So that means that whoever's executor either had access to some account that isn't probate property, or they're using their own money and credit cards, and they're going to try to get reimbursed from the estate later. So this can cause quite a bit of discomfort for whoever the one that takes responsibility for this, where they don't have access to the accounts. Okay, what about a trust? Okay, so because the trust is supposed to be easier, so what's the gap there? Okay, now this depends on whether you have you're talking about a successor trustee or a co-trustee. So remember this, a successor trustee only takes over if you're disabled officially or you pass away, okay? So a successor trustee doesn't have any power while you're trustee until you are officially disabled or you pass away, okay? So how soon can a successor trustee do something, get hold of something with the trust? And the answer is about 2 weeks. So you say, well, how come 2 weeks? The reason is that they're not going to be able to talk to the financial institution until they get a death certificate. Okay? So that's the gap. Once they have a death certificate, then they go to the bank and they can take charge of that account. They can sell property. They can do what needs to be done on those accounts. So you got a 2-week gap in that case. Okay? So you say, wait a minute. What about co-trustee? Okay? A co-trustee. So like husband and wife co-trustees, is there a gap? No gap. Okay? Remember, both spouses are trustee, both of them are on the account. One of them's disabled, one of them passes away. It should have no effect on the account. The co-trustee can go right on writing checks, doing whatever they need to do. Okay, so there's no gap if you have a co-trustee. Well, what if, and that's one of the key reasons why when we're talking about planning, when I'm talking with clients, that I usually suggest that at the first death, after the first death, that they add their son or daughter as co-trustee, whoever would be their successor, as co-trustee to deal with exactly that problem. I mean, that's part of the convenience of the setup that while husband and wife are both alive, it's likely that one will pass away before the other, and whoever survives will have control. So there's no loss of continuity there. Then one spouse passes away, the other spouse brings up one of the kids as co-trustee, or two of the kids as co-trustee, so they're then available to take over if something happened to the surviving spouse. So there's no loss of continuity. Okay, what if you have a husband and wife, they're co-trustees, and they both get run over, okay, at the same time, okay? Then you got the 2-week gap. Okay? So you say, well, all right, I'm worried about the 2-week gap, so how would I handle that? So what some families do, when they're trying to avoid any gap at all for that situation. They would have perhaps a their joint checking account and some maybe a related savings account at the bank, and leave it in joint tenancy with right of survivorship with the husband, wife, and daughter or son as co-owners of that account. And that would mean no gap, and there would be money to pay funeral expenses right off of that. Okay? Question about gaps?
How you show that you're a trustee of this is the letter, what do we call it? Certificate?
Affidavit of trust.
Affidavit of trust. Does that necessarily show who the next member to take over is?
Okay, so, yes, the long form does, because it has the trustee provision in it. So, yeah.
Okay, the short.
The short form, some versions that we've done have it and some don't have the successor trustees on the short form. So you have to look at yours. The long form has the trustee provisions with it.
Okay, so that's in the trust document.
Yep.
Okay, I think the little short one does not have that.
That may be right.
I've been somewhat, how in the heck does, in other words,
There should be a long form right behind it, and it says the attachments include the,
that 50 page or so?
yeah, and that includes the section that has the trustee provisions.
Oh, yeah, okay.
And it says on the front of it which of those articles it is. It's Article 3
Yeah.
has the trustee provision.
Yeah, when you go to get your trust document, what do you call it, registered in the counties and so forth, they start counting each page and it gets expensive in a hurry.
Well, now, yeah, so you want to use the short form, and if that was an issue, now he has a special situation because he's got mineral interests in a lot of places, and he's having to show the ownership of that. So most people don't have quite that.
It's also another thing that you're talking reasons to avoid probate, because
Oh, yeah.
I'm uniting properties of my wife and I, so that eliminates some. And then I've got property in 4 different states. And a probate is good for one state only.
Yeah, and then you have to go to the next
And
page.
so
Wow.
if I hadn't changed anything, I would have had, my son would have had to go through 8 probates.
Too much to think about.
That's the reason I'm here.
Okay, so this is talking about the non-probate solution, and we've really been talking about that all along, right? We've been talking, what's probate, what's not probate, how we want to use the trust to put on our probate property, and for most people, for most husband and wives, we want anything that would have been probate property in the trust, which would be after-tax investment accounts and real estate we want it. Also, we prefer that your joint accounts with right of survivorship were also in the trust, so you don't confuse yourself. And then the only thing outside the trust is IRAs, annuities, and maybe life insurance. And those are governed by the beneficiary designation. So it's set up. And remember, we don't care about cars and trucks and so forth. A lot of times we do what's called a survivor's agreement on those to simplify it, but in any event, they're not going to force probate on that. Now, when I say it's not going to force probate, that doesn't mean you aren't going to have to do a lot of paperwork on this stuff.
Yeah.
Don't misunderstand.
Yeah.
This is another misunderstanding about this. Okay, paying estate tax. Okay, some people, this used to be, people aren't having to think about it much anymore because we don't have to worry about paying estate taxes in Texas and most of the United States because the estate tax exemption is so high. Just a few years, 20 years ago, 10 years ago, estate taxes were a big deal. And they're still a big deal in the upper Midwest, East and West coasts where they have state death taxes, but Texas doesn't have such a thing. But one of the old misconceptions was that if it was in a trust, you didn't have to pay estate taxes or something. That's not true. The way the estate tax was written, everything you own or control is in your estate. So it doesn't matter whether it's joint accounts, trust accounts, beneficiary designation, all that. If you own or control it, it's part of your estate for estate tax purposes. It's just, right now, the estate tax is so high, you don't have to think about it, which is a good thing. Does that make sense? So we're not gonna have to think about that. Now, there's a whole bunch of other tax issues you do need to think about, or somebody needs to think about for you. I think we're gonna come on that in a minute. So here's old Bill and Mary. And so we're gonna give an example here. They have a house, checking account, and a vacation home. They have an IRA, it's payable to Bill and Mary's children. They have retirement plans for $300,000 payable to Mary. Life insurance policy with an outdated designation naming Bill's ex-wife as a beneficiary. Does this sound like a problem? Well, it's a problem. However, it's not as big a problem as it once was, because in Texas, a life insurance policy with the divorced spouse on it is I don't know what the right word is, void. Now, if the divorced spouse makes it the insurance company first and puts in the claim, there could still be a problem, but legally she or he would not have a right to it under Texas law. Okay. So the divorce ends life insurance beneficiaries designations. But at any rate, this is a poor plan to leave. Yes?
I am so sorry. When you say that, if that's who they wanted to be the beneficiary, would that still nullify it, or would we have named the living trust as the beneficiary?
That is a good question, how that's sorted out, because that definitely does happen. That they name the, it may be that the issue is whether the date on the beneficiary designation is before or after the divorce.
Okay.
It may, that may be, because insurance companies like to use very literal, simple things that they can work with, because they're all in the memory and everything. So I think that's probably how they would work it, is the question would be, it would be not valid if it was before the date of divorce.
Okay.
Or put another way, if they divorced and then one of them was going to make the other a beneficiary, they need to do a new beneficiary designation with the date on it. Okay. Now,
I'll look it up for you. I knew that's what you were thinking. Yeah, I'll look it up.
This is the life insurance, this is not.
now another wrinkle on this whole deal is, this may be extreme, but we've seen in the last couple of years several times where we were settling estates and the wrong beneficiary was named. And the one that comes to mind was where mom had passed away several years before, and then dad passed away. So the family came to us when dad passed away. So then they're looking at all the assets, and they found that dad owned a life insurance policy that he had bought years and years before, and he had named his wife as the beneficiary. Well, she'd been dead for years. So this is a big problem, because now you gotta open an estate for mom. Mom's will of her estate was never probated. So just an unnecessary cost and trouble, right, where you have a deceased person named as a beneficiary. And what would have been the solution? Well, if at the time that was set up, he'd named his kids as the backup, right? Or if we'd updated that later, he could have solved it. But it's one of those things that never got looked at, and didn't realize they had a problem. When mom died, they apparently didn't find it, didn't think about it, or just overlooked it. There's that family right there. The family home, Bill and his sister each have 50% interest, but the house is still in their mother's name. Holy cow. So Bill and his sister own the house, but the house is still in their mother's name. Are we having fun yet? Now you think that is really weird? We see all kinds of weird things in real estate all the time. And the reason it happens is that somebody passed away and nobody went to probate court. And if that happens a couple of times, it is really a tangled mess on trying to sort out ownership of real estate. So, I don't know. some of them are almost funny, but it's not funny to the people that have it. They're trying to do something with the property, because it tends to just tie it up. Savings account, Bill and Mary, Jake, so that one's gonna be, non-probate property, just go to Mary. Okay, so complications within the state. Ownership of assets is confusing. It signals potential trouble spots ahead. Many areas may be open to a challenge. In our example, we've got Bill and Mary. They've got their daughter Susan and then John. And after Bill passes away, there may be immediate problems. There could be long-term problems. And what role will the wife or kids play in handling this estate? So Susan, their daughter, her husband's unemployed, she has a special needs child. John, their son, a former spendthrift, now responsible and greedy. Frank, a long-lost brother of Bill, says Bill owes him $50,000. Now that is really ugly. I don't know if y'all have run into that. The more common one I've seen is where there's a scam where if someone dies, and like an obituary in the paper, then people will say, it's like Ace Electric sends in an invoice with a bill for some electrical work that was done in the month before the person died, right? And they're hoping that the executor won't know any better and will pay it, that kind of stuff. So you do see a lot of scams.
You mean like doctors sending in medical bills and so forth?
I don't know whether they're crooks or not, but the guy that claims to be an electrical service that didn't do any electrical work is clearly a crook. But it might take many versions. I don't know how that would work. Good point. Now, if the poor guy died and he's got a business, man, things are, and there's no planning. Well, everybody's in a jam at that point. The employees are in a jam. The family's in a jam where dad had an interest or owned this business. If there's money in the bank accounts and his wife or other kids are not on that account, it's going to be frozen until they can get the probate approved. So this lists all that kind of stuff. The gardener says Bill promised him something. That's happened before. A frequent thing that happens is one of the kids says, and I see this fairly frequently, one of the kids says that, Mom promised me I could have that. And then one of the other kids said, wait a minute, I thought Mom promised that to me. And that's a real source of controversy or disappointment or whatever you want to say, or conflict. So that's another good reason for writing it down and making sure the family knows, hey, I made a list. Follow that. But some families are just set up for more conflict than others. So in her case, how does she keep the business going? How does she prevent this kind of problem from happening when she dies? So one of the concerns about probate is that it creates a public record, right? The will is a public document, the inventory and appraisement is a public document. Now, Texas courts have tried to limit that in recent years because it used to be a business model where people would go look at the probate records, they would go look at the inventory and appraisements to see if there were things that, that might be bargains to buy, and they'd go approach the executor or family members about stuff that they might own. But it gave everybody the creeps that the will and the asset information might be available to the public. So I don't know how much concern that is to anyone in particular. I know it's a concern for some. As I often tell, I had a client that lived in a small town outside of Houston, and she was a big deal in this community. And she was also one of the richest people in that community, and she had all kinds of lawyers, and she knew everybody in town. She came to me to do her estate planning, and she wanted a trust because she did not want everybody in town to be able to go down to the courthouse and look at the will and inventory and appraisement in town. I don't know, we feel more anonymous in the big towns than people in small towns do, but she wanted no part of that. Okay, this is what I was talking about in that gap. Remember I was talking about the gap? And so this is very disconcerting for family members who are trying to settle an estate if they're not sure when and how they're going to get hold of the main assets. And so that's why it's good for your peace of mind and your family's peace of mind if you address that, okay, what kind of a gap here and what can we do to make sure there's money available? And also, what's the plan? Because a lot of times if you don't talk to them, your kids really haven't got a clue, right? Not a clue. Somebody doesn't have a clue about how to handle it. And that's the other thing. Everybody's going to have an estate, most likely, but most people don't have that very much experience in actually settling an estate, right? We're probably only going to have experience with our parents, and depends on how all that plays out as to how good an experience it is. Okay, let's talk one area that's very uncomfortable to people, or several examples. Sometimes the client doesn't even know there's an issue. If you don't know there's an issue, then you can make really great big mistakes with taxes. And I guess maybe ignorance is bliss, but it's not, in the great scheme of things, you'd rather pay less taxes than more taxes. So the income tax issues, let me see if I can talk about this. First, on the income tax front, you need to know that when a person passes away, the property in their estate, the stocks, the bonds, the real estate, the ranch interest, the mineral interest, all of it gives a new basis for income tax. So this is, when I say that, this is a good thing. It just erased all the built-in capital gain that's in your assets. And it means that if the executor sells that property, or the trustee sells that property after the death, or the surviving spouse sells the property after the death, there should be very little, no or very little gain. Okay, so this takes some of the sting out of repositioning assets. So that's a good thing. It also means that the financial institutions all need to know, if you have stocks and mutual funds, they need to update their records for date-of-death values. Most of the big financial institutions, like Vanguard and Fidelity and so forth, they have their own estate section. If you tell them somebody passed away, then they will recalculate what the basis is for the assets that they hold of yours. So that's a good service. Sometimes some financial institutions don't do it, and if we do it for clients, we use special software, because it's not just a question of finding a Wall Street Journal of the right date and writing down the value of the stock or mutual fund on that date. It's an odd number, and the odd number is it's halfway between the opening and closing value on the date the person died, or if it's a weekend, it's halfway between the closing on the day before they died and the closing on the day, the next working day after they. And then it's also, if there's accrued dividends, you're supposed to calculate that. So anyway, it's not a fun activity for to do, especially if you have an extensive amount of mutual funds and stuff. So you want the financial institution to do it, or it needs to be done as part of the estate settlement process. Now, the step up, of course, applies to homes. Now, for married couples in Texas or single people in Texas, on your home, you have that federal exemption from capital gain. It's $250,000 for a single person, and it's $500,000 for married couples on your home. Well, so for most Texas people, if you sell a home that you've lived in for two out of the last 5 years, and it's your domicile, unless you have more than $500,000 in capital gain, you won't owe any capital gain tax on the site. Okay, so that's a good thing. Yes, ma'am.
Okay, Mr. Bond, I have a question. Dale and I, we have the same name, same first and last name, and we've been divorced. Okay, so but when I bought my home in Willis, I bought it my name, and I put Dale's name under there because it would be easier for him to sell if something happened to me. So what happens in that? I mean, he can still sell it, and he won't have the capital gain, correct?
So, okay. So
Even,
if you get run over,
yes,
okay, he can just rely on the step up in basis.
because,
See, you're just going to step up, so there wouldn't be any capital gain.
oh, okay.
what we talked about the
Yeah.
other property.
No.
Well, okay, but see, that's the kind of thing that's confusing, because on the one, if you're married and alive, you get an exemption from
Well,
capital
I'm
gain.
getting confused, cause when you're sitting there saying married or single, you know,
Yeah.
we're divorced, but we have, I mean, you know, what I have is vice versa, you understand?
Well, technically, if you're not married, then, and the house is yours, then it would be a $250,000 exemption. from
But his
gain.
name's on the house.
Well, you could tell, you might be able to confuse the IRS on that.
Oh, I got you, okay.
But
Okay.
you know, technically, the rules, you're just supposed to follow the rules, so if it's your
Right,
house,
right.
then you get the 250,000 in exemption from capital gain.
Right.
Well, unless you've got a lot of capital gain in Texas, that might cover it anyway.
Okay,
Yeah.
okay,
Because we're only talking about the difference between what you paid for it and what it's sold for.
okay.
That so $250,000
Right,
is
okay.
a pretty good gain to begin with.
Okay.
But in any event, if you were run over, it would step up. So in either scenario, it's
Okay.
going to be a
Okay.
cut.
Yeah.
Now, if it's not your domicile, well, while you're alive, you don't have 250 or 500,
Right.
neither one. But it would step up if you pass away.
Okay,
You've got all kinds of problems with getting property and so forth, because some of it, back when we had the lower ceilings, you have to then, when somebody dies and leaves you a piece of property, then you have to go hire an estate estimator that's, you know, got lots of things after his name, and you tell him what kind of value you want placed on it, and then he gets as close as what you told him that will satisfy Uncle Sam. And so I got some property that came in at ridiculously low value, because that was trying to avoid inheritance tax.
I got you.
And
Okay.
then later on, I decided to sell it.
Oh.
Oh, did that?
Well, yeah, right. See, that's how the tax law works. Good one way and not good the other way.
Right.
You know, these different games we play with valuation.
Yeah, so
Yeah.
Uncle's there to grab you one way or another.
Wow.
Now, what we normally use in Texas, if the house or property is sold within a few months after someone passes away, we'll use the we'll use, if it's sold within a few months after the person dies, we consider that sale price to be the date of death price, and therefore there's no capital gain.
Okay, that's what I wanted to ask you. Dale has got some property in Florida and Oklahoma, businesses. And if I have to sell it, or if it's in the wheels, or the, what is it called again? The
LLC?
yeah, if it's in the LLC,
Yeah.
and he says, okay, you can go ahead and sell it. So it needs to be sold within a couple of months of his death, is that correct?
No, you don't have to, but that would just,
No.
well, all we're talking about is the capital gain.
Gotcha, okay.
You still get the stepped up basis, whether you sell it the next day or 5 years later.
Yeah,
You
yeah.
still have a stepped up basis.
Okay,
I was just talking about,
I was telling you just sell it to them up exactly.
I got you.
you know, some people are just like, okay, what am I gonna have to do on this tax return here?
Yeah.
You do the probate bit, you gotta do probate in Florida.
Okay, and I wanna get this straight, we don't have to do probate stuff. Okay, thank you, Lord Jesus, thank you.
Yeah, so, and like you said, if you've got stuff in other states, you just really want to have a trust. Really.
Okay,
No two ways about it. Okay, retirement plans. Go ahead.
I didn't hear you.
I said we have Florida and Oklahoma.
Yeah.
Okay, well, are those states different from Texas?
Well, you have to do a probate in there if it's not in the trust.
Well, have you already done that?
Yeah, that he did. That's what
Okay,
she did.
I
Yeah, Florida is terrible if you don't have a trust.
Okay.
Probate gets a hold of you.
okay.
Just let you go. The retirement plans, okay, so if you're named as the beneficiary on an IRA, and, well, the person dies that's named you as beneficiary. If you're a spouse, then you can do a spousal rollover, okay? A spousal rollover means that now, in that process, the IRA is now gonna be in the surviving spouse's name, and it's just like any other IRA you're used to. And if the surviving spouse already had an IRA, those accounts can actually be combined, okay? Now, the other part of this is the surviving spouse then needs to name the kids as the beneficiaries, update the beneficiary designations, in other words, or name the trust for, if the kids are gonna get into the trust, then you need to name the trust. So we need to update we need to do spousal rollover and update the beneficiaries. Now, if the spouse is less than 59 and a half years of age, you do not want to do a spousal rollover.
Well, we don't have to worry about that over here.
But there are sometimes wrinkles there.
I have a question.
Yeah.
What about non-spousal beneficiary?
Okay, so good. Thank you for asking. So when kids or non-spouses get an IRA, it does not work the way it works for us, the way it's normal. So you just stop. It works a different way. It works great, but it works a different way. So if I got run over and I named my son and daughter as beneficiaries of an IRA, then after I'm gone, the IRA will be the Robert Bond IRA for the benefit of Natalie, or the benefit of Will Bond, okay? So it's gonna be titled a different way. It's gonna have my name, FBO, for the beneficiary. Okay, once they get it, they can't do a rollover. And this cannot be combined with their IRAs. It's a separate gizmo, okay? But it's very desirable. The most desirable way for them to take it is as an inherited IRA. And what that means is that they have to take distributions beginning the year after I die. So with your IRAs, you have to take distributions, or mine, everybody here, your regular IRA, you can't take distributions until you're 59 and a half unless you want to pay a 10% penalty in addition to the income tax on it. And then when you're 70 and a half, you have to start taking distributions. None of those things are not true for my son and daughter with this inheritance. They have to take minimum required distributions the year after I die, based on their life expectancy.
Do they get the option of taking it out lump sum, or?
Yeah, they can take it out faster. But they'll just it's all gonna go on their tax return. And so it's gonna drive them right up through the brackets, and so it's a very tax inefficient approach to take it directly. It's better from a financial planning standpoint, it would be better for them to take it as an inherited IRA. It stays in its IRA wrapper. It's growing tax deferred, and then they take minimum required distributions. They can take whatever they want out of it, but it's growing tax deferred until they take it out. When they take it out, it's going on their tax return. Okay? It's ordinary income at that point. There's no step up on IRAs.
What if the decedent and the beneficiary are over 70 and a half?
It's the same thing, except what's odd about it is that the distribution period on the inherited IRA will be shorter than the distribution period on your traditional IRA.
And why would it be shorter?
Because you use a different table for the distribution period on your traditional IRA versus an inherited IRA. So I don't know how much y'all want to go down to this, but you just think about it. The first year you took distributions, are y'all taking minimum required distributions? Yeah, so if you're taking minimum required distributions, the first year the factor is like 25. One of the factors is 25, I think it is. Anyway, if the factor is 25, then you have to take out essentially 4%, 1/25. So you take out 4% the first year, okay? And that 25, or whatever that number is, that is the joint life expectancy of you and somebody who is, I don't know if it's 10 years younger or whatever, I'm not sure what it is. But anyway, it's a joint life expectancy, because at 70 and a half, an individual's life expectancy is not 25 years. Okay? It's a joint life expectancy, and they did this so that you wouldn't exhaust your IRA before you passed, necessarily exhaust it before you passed away. So they gave this longer life expectancy. Also, it's more in keeping. For married people, that sort of fits. one, if you have a husband and wife, the chances are that the two of them do have a life expectancy, that one will live close to 25 years. Okay? So it is a joint, that's what it is. But if they go to the single life table, a 70-year-old's life expectancy is like 15 years. Okay, so then, and that just tracks what's your expected life expectancy? About 85, right? So it's what a single life expectancy.
Just one quick question, and I'll get off of that. You said it was a different table on the IRA that goes to a non-spousal beneficiary.
Correct.
Is that table based on, I know it's a different table, but whose age is it based on?
It's based on the recipient's age. Yeah, the recipient's age. Now, you can get a situation where it's based on the decedent's life expectancy. You say, wait a minute, I didn't know the decedent had any life expectancy. But we don't want to go into that.
Okay.
Okay. Well, we'll come back. Okay, so this says income tax issue, selection of the estate's taxable year, who pays the income tax, the estate or the heirs, time of the income distributions, deduction of trustee and attorney's fees. So there's frequently there's a bunch of questions just about, okay, what am I supposed to do during this estate period? Now, in simple estates, or where we have very little probate property, maybe I shouldn't say let me say it this way. If someone passes away, we nearly always get a tax ID number for the estate. Now, it might be a probate estate, or it might be the trust estate. It can be either one. But at any rate, we have to get a tax ID number for that. And we do that because otherwise the client will go to the bank, and the bank says you can't do whatever you want to do next without having an estate tax ID number. So I don't want the clients to get hung up at the bank or with other things they're trying to coordinate. So we nearly always get that tax ID form at some point. Now, what the IRS is expecting is that after this estate closes, they get an extra tax return. Oh boy, a 1041. Okay, so let's think about it. Somebody passes away this year. The income that comes in under their Social Security number is going to go on their 1040 next April 15th. The income that goes in on goes on the estate tax, this estate income tax ID number, that's going to be on a 1041. Now, as far as the IRS is concerned, all the income that comes in from date of death until date of distribution should be on this 1041. But as a practical matter, if it's under the person's Social Security number, we put it on their tax return, and if it's under that other tax ID number, then we put 1041. Now, the happiest thing that can happen to the family, in the simple case, is no income comes in under that extra tax ID number, and we don't have to file the extra tax return. We only have to do the one for dad or mom passing away. Does that make sense? Yeah. But frequently, there's going to be two tax returns for the decedent in the year after they die.
Two tax returns.
Yeah. One's a 1040. That's their personal tax return, the last tax return for them, and then the other one's for the estate.
Okay, and that's you said 1041?
1041. And there's very little software for this. You're in the land of attorneys and CPAs. The rules are, the explanation of it is in Greek or Chinese, so it's not worth thinking about. Okay, so we already talked about capital gains and stuff. We already talked about real estate. We already talked about minimum distributions for IRAs. We'll talk about that later. Business owners have a big problem. You guys aren't business. Well, you have a business, but
Had
but you don't have employees and stuff right now. So we won't go on that. So now, the probate's not the end of the world. So what does it cost to get the judge to do the letters testamentary? It costs about $3,500 in our office to do that. Okay, said it takes about 8 weeks. And what our goal with that $3,500 and getting that letter is to finish up all the responsibilities with the court as quickly as possible. So after we get letters testamentary, within a fairly short time, we try to submit the inventory and appraisal. There's stuff that has to be done, notice to creditors and so forth, and then the final thing is to submit the inventory and appraisal to the court, and that way we're finished with the court. Now, if the will isn't in good shape or there's no will, then all those bets are off on getting that thing done at $3,500, much less getting it done with speed. So we want to make sure that the wills need to be. They don't have to have a lot of things, and it's pretty standard. But if they don't have them, you're out of luck. And so we want to make sure. We always want to make sure that's the right stuff, and you all have the right stuff in your wills.
Good. Because if we don't,
You're gonna be mad at me. No, you got the right stuff there, so don't worry about that. Okay, so here's. Well, let me just. So it's called in California. If you go through a probate, they get a percentage of the estate. Arizona uses reasonable compensation, and Texas uses reasonable compensation or 5%. Okay, so but we're not talking about the attorney. We're talking about reasonable compensation for the executive. So, and like I said, Florida is famous for the cost and the trouble of going through probate. And this is just an example that the probate, the figuring the percentage, calculating the percentage in some of these states, they don't subtract for the debts. They just use the gross value when they can do these calculations. That's not much fun. And then this talks about it taking a long time, bringing in creditors and stuff. We already talked about if you got property in other states, you need to have a trust, period. Okay, now this slide is talking about, so this is one of the things I wanted to tell you all, because there's a couple of misconceptions that go on. One of them is that my goal, and a lot of people have this goal, it's not a bad goal, it just isn't going to happen. The goal is that if I arrange my affairs just right, I could pass away and the Neptune Society would police up my remains and my family wouldn't have to do much of anything, right? It would just slip away. So this is never going to happen. Okay. Now another thing is that since with a trust we can avoid probate, this clicks another switch in our minds. Okay, we don't have to do probate, so we must not have to do much of anything. Not a good approach to take to this whole problem. So just think about it for a second. If someone passes away, there are at least dozens of things that have to be done.
oh Lord, I know.
And just, I mean, I don't care how you sliced it, there are a jillion things. And plus, it's going to be a pain in the tail for somebody. And if it's not very well organized, well, even if you tried to organize it, there's a certain flavor of the scavenger hunt involved, which lasts for weeks or months as here comes another statement. I didn't know anything about that one. What's going on with that, right? And so all this kind of stuff goes on for a while. So somebody's going to have a major task to do. The question is, so this is getting on through this thing, create the trust and fund it. Let me talk most of this stuff. So go to another section here.
We got all day, Mr. Bond, all day.
Well, I'm gonna stop right here and just say a couple of things. One of the big, if someone passes away, there's things the family just has to do, right? I mean, if there's hardly any substitute for family or loved ones, they're gonna have to sort out all the personal property and all that kind of stuff, and figure out where everything's located, and locate all the account statements and stuff. So there's just gonna be a lot of work. And then there's a whole nother dimension of work having to do with these tax issues, having to do with actually dealing with accounts, dealing with banks, getting stuff changed over. So whether you're doing a probate or whether you're doing have a trust, there is a lot of dealing with financial institutions, tax questions, and the family, for the surviving spouse, the very frequent mode is that the surviving spouse is really in a very bad state of mind for months, and it makes it really hard for them to come to grips with details and all that kind of stuff, and especially details that are tedious and frustrating. It just adds more, just a huge weight. So the person that's trying to handle this needs help doing it. And so the law firm, or being comfortable with a law firm, can be a huge help to the surviving spouse in this situation. And then if you think about it, well, what if it's not the surviving spouse, it's the kids? Well, the kids, they're busy with their own life. They got jobs and everything else. And here they're faced with administrative tasks that are tedious, that constantly frustrate them because they don't really know what the next step is or what to expect in the process. So once again, the law firm is a huge help in this. So avoiding probate, quote unquote, is the $3,500 in the 8 weeks is really nice to do, but it's not the game. And every family's that nearly every family is going to want assistance in handling the estate. So this is the estate and probate, the trust or probate administration is where the family needs help with getting everything back to the stable or distributed to the beneficiaries or reorganized for the surviving spouse. So that needs to be done. So you say, well, now what is that going to cost, right? Because this is expensive stuff to do, and you hear all kinds of things. So what is the calculation? How do you think about it? So I think that in Houston, that the cost is between about if you just were trying to come up with a number, you'd say it was somewhere between about 3/4 and 1.5% of the value of the estate. Now, some law firms actually calculate it. They'll just tell them, they'll say, what have you got? And okay, it's going to be 1% of the fee, and you're going to pay this much. I have always thought that was kind of a hard way to come by that number, because calling it 1% or whatever the number is doesn't seem like that gives the client any real idea about what's going to be done. It's just like a totally huge number. What are you going to do? What's going on here? So what we do in the law firm is we don't calculate it like that. We just calculate it based on what we see as needed to be done. But it's expensive to do that stuff when we do. So it's not that we do a percentage, it's that we talk with the client, we figure out what tasks need to be done. And then we typically do a flat fee, so whatever that number is. So that's kind of how we do it in our law firm.
Do you have a list? Do you have a list somewhere that you keep that if something happens to Dale or vice versa, that we could just go down that list? Besides, it says call. I was told if something happened to him, call you. Okay, I was told that. but, you know, I mean, y'all aren't gonna take care of the bills or anything, I know I have to do that, but I'd like to have a list.
Yeah, we do have a couple of different checklists. Yeah, you might wanna look at those and see if you don't think they're good enough or they're not answering your question, let me know and I'll try to look at that one too. But we do have a couple of them that we provide to clients.
Okay, okay, or you need to make me a list up and this is what you need to do.
We can do that. Thing about it is though, that's kind of a moving target, and at different times, you have different things on that list.
Yeah.
So we change a little bit, so all you do is try to get the bulk of it that you know you're gonna do. It could still be something that somebody like him would have to advise you on.
Yep.
Well, plus, and also it's a comfort that somebody else is, you know, like Stephanie, that I've been working on this for years and years, so she knows, yeah, it's gonna be a hassle, but she knows how to get through it. And what, you know, the bank says this, I have to remember this.
Oh, okay, okay.
Yeah, we need to fill out this, so you need to fill this out before you go to the bank, or before we gotta get you to sign this before we go to the bank.
Okay,
So it's all that kind of stuff, so it helps to lower the frustration level and get the process.
right,
Also, if you hire us, then you kinda have we're gonna give you an idea, okay, we're gonna have this meeting, and we're gonna do this, and this meeting, we're gonna do this, and by this time, we expect to have this stuff back, and then we're gonna close out by doing these things, right? So that's, it gives a sense of, okay, what do we gotta do, what's gonna needs to be accomplished, and how long is it gonna take? So
Yeah.
and otherwise, this thing just goes spiraling out into the future, right? Because you don't really know how to finish
yeah.
the deal. Now, another thing, when it comes to when it's after the husband, another thing to know, and of course you really kind of know this intuitively, a lot of times the probate is easier, or the trust administration is easier when the first spouse passes away, because things are relative, you know, it's the surviving spouse already knew where everything was, or a lot of times they know where stuff is. So the transition is simpler. When it goes to the kids, it's more difficult, okay? When I always tell the people that are settling, I said, now, if it's a loving family, then you need to be very transparent, very careful and meticulous in keeping track of this thing. And then we want to make sure we provide an accounting so everybody knows exactly how this worked out. And I said, if the family is not on good terms, you need to be extremely meticulous and transparent. It's the same thing, right, in spades. Okay, and also the executor, if they don't, or trustee, whether they know this or not at the beginning, they will certainly know it at the end, and that is, they want to be done. They want to know, okay, boom, I got to the end of this thing. And also, if there's any tension, you also want to know you're not going to be sued. Okay? So that's another thing the law firm does. We try to get them off to the right start. In the end, that there's going to be a spreadsheet. It's going to have the date of death days on it. It's going to show what the expenses were. It's going to show what was left, and then it's going to show what each person shared. And then the typical mode in settling the estate is that we write a letter, either a letter that says, I'm just about to make the main distribution of the estate, and I'm providing you a copy of the spreadsheet showing the value of the estate when mom or dad passed away, and it lists the expenses, and it shows the shares for each of the beneficiaries, and it calculates yours. And out of that, I'm going to distribute this amount to each of the beneficiaries. And please sign the attached agreement and release that you are satisfied with this information. If you're not, let me know. If you send back this attached release, then I'll write the check. Okay? And so we want to, so in a friendly family, the letter will be friendlier than one that's less happy. But the point is the same, that we want to let them, here's the deal, if you have any questions, if you're happy with this, I'm sending you the check. If you're not happy, I'm going to wait till I can get everybody's happy with this stuff. Okay, so that's when the main distribution is going to be made. A little bit is going to be kept back to pay for the tax returns or whatever is going to go into the next year, or whatever the executor trustee thinks. But that's sort of the process, and that's the way things need to be handled. Happy families and unhappy ones. So that make sense to you guys?
No.
Okay, now, those slides I clicked through were trying to convince you should get a trust, but you already have a trust, so I'm not gonna try to convince you that some more. And we've already talked about some of the pros and cons with that. So, let me talk about another thing. Okay, another dimension of this whole, estate problem is this. That for family life savings, this transition is extremely dangerous. Okay, so why is that? Well, a lot of times when the first spouse passes away, if that spouse was the one that was handling the finances, the surviving spouse is less comfortable with the whole arrangement. Okay, so if the stock market is not doing well, the surviving spouse is going to be uncomfortable with this new responsibility for handling this stuff. So what does the new spouse do, or the surviving spouse do? They will hear things that make them even less comfortable. Just think about the stock market last fall when it would just go down, go up a little bit, shoot down, and as each time it went down, all the media just got louder and louder and louder. And so this makes people tremendously nervous, and especially this surviving spouse. So what do? They do what is rational to them under that state of mind. Since they're not sure about what to do, we want to go to safety. Okay, so whenever the market's going like that, there are a million, perhaps well-meaning, perhaps not, people who want to sell annuities, or they want to sell, or it's the banker and they like to get CDs, and so that sort of anxiety plays on that, and so then the surviving spouse will switch to safer investments, and the effect often is a permanent haircut to the investment portfolio. Let me give you an example that actually happened here in my recent little experience, just in the last few weeks. I had people come in, and the planning was for Medicaid for Dad. Okay? And the reason was Dad had fallen and he fell in a bathroom and damaged his brain. Really terrible story. But Dad had been in kind of declining health in the fall, and the stock market was going down. Well, the healthy spouse was extremely nervous, and she sold their Edward Jones investments in the week before Christmas. If you recall, the week before Christmas was the low point of this dive where the market crashed from September to Christmas Eve. Okay. January, as the Wall Street Journal reported in February, was the strongest January for the stock markets in 30 years. Okay, so what did she do? She took a $240,000 portfolio. It went down to 200, and she sold it and put it in CDs. And I don't think it's coming out of there. So that is a huge, huge mistake, right? So families need a strong financial investment concept, and they've got to some way build in comfort for the husband, wife. And now you say, well, my kids, fortunately, are all smart, highly educated, and so they'll just do fine. This is another myth, okay? Even if they are highly educated, smart, and stuff, they're probably not going to do well with this inheritance, because nobody seems to know what to do with an inheritance when they get it. I am always stunned by this. Okay, so let me picture the mind frame or frame of mind that I see in grown, quote, responsible children upon receiving an inheritance. It is almost like they feel, okay, this is a huge opportunity. I've got to do something with it. Let me think. what can I do? See, well, first I'm pay off my credit cards, that's for sure. And then I'm gonna pay, I think I should pay off my mortgage. Maybe I just get a bigger house. Pay off my mortgage and get a bigger house, right? But so get that money gone, okay? Well, now's my chance, you know, the first time I really had a chance to have money I could just figure out how to invest in, and as you know, you can make a fortune in the stock market. I mean, if you don't hear this on the radio, the Online Trading Academy is waiting for your highly educated children to learn how to day trade. There is no there, okay? No there. If you do well in your online day trading, it is only because you were lucky, because it's the only thing you got going for you. And this is not Bob Bontalk, and this is Nobel Prize winning research. There is nothing there. Okay, and yet on the radio, it just sounds like the most reasonable, prudent thing you could do is go learn about how to day trade. Are we having fun yet?
Highly educated.
Okay, also, if you notice on the investment ads on the TV, any person can just go to Schwab, even a baby at Schwab can invest, right? Anybody can do it, and they just have all the information you could possibly need. Now, anybody that's ever invested for any length of time knows this is not going to fare well if that's your view of the world. So here's what happens. Even though we have highly educated, smart kids, one, they didn't know what to do with this. So they wanted to deploy it right off the bat. Now, it took you a lifetime to save this. I don't know why they have to be in a hurry to deploy it. Secondly, they can't make a distinction between personal assets and investment assets. Right? If you don't make that distinction, you're not going to be a saver for very long. And then, because they don't have any experience, they get to take another haircut learning how to do this. So, a few blessed families can pass money from generation to generation. Wouldn't we like to be one of them? Okay? If, in order to pull this off, your kids have to understand that the best use of your inheritance is not to spend it. The best use is to invest it wisely and take distributions. So, at any rate, that's another role where the family needs to have a strong concept, and this is also where a financial advisor can be a huge help to the family. So, what are your thoughts? Let's see, what else do we need to wind up with? I think I might have said all I have to say this afternoon on this. What about questions? Other questions? Is there something you think of I haven't covered about estate settlement?
No, I'm good.
I've been through a probate a couple of times. What's the typical happens with the trust?
Well, in one sense, it's the same, except you don't have to go to court.
Okay.
Right? Because the trustee's got control from the day he gets control, and he gets control as soon as he shows he has authority. And so, like we were saying, the successor trustee can take charge with the death certificate, right? And so then he's
But
on
a lot of the properties, the certificate of trust, I think that I've got, does not mention the successor.
Well, he's got the trust, and he's got the long form affidavit that does.
Okay, the long form, and
The trust
most
itself.
of the companies that I deal with, and also all the counties, that certificate of trust has to be registered. And how, the county's little stamps and so forth, you gotta pay your $40 and.
Well, just to answer your question, if someone had a mental interest like you're talking about, or real estate, we do an affidavit of trustee, an affidavit of trust for real estate. And so an affidavit is filed in the deed records of each county where that property is located. And so instead of
Yeah.
working with letters testamentary and creating deeds in that fashion, we can use an affidavit to show who the new trustees are. So that's what we file. And then that gives the new trustees, the power to sell the property.
Yeah.
Okay, so instead of going to court and then providing a deed or a letters testamentary, then all we do is do the affidavit for each county.
Why was the first one done without showing the succession to where all the person would have had to have done would show a death certificate?
So, no, you still have to submit a new affidavit because we gotta show who's in charge. And typically you don't file death certificates, you gotta file something else.
Oh, okay.
So you don't, the death certificate, you may refer to it, but you're gonna end up doing an affidavit or something in the deed, something's gonna be in the deed records. So
Yeah.
it's an affidavit. So at
Alright.
any rate, so every time if someone passes away, we're gonna do a new affidavit and file it in the county where the property's located, and it'll show who the new trustees are.
Yeah.
That's what the point of the affidavit says, so-and-so passed away, and
Okay.
these are the trustees.
Okay, so in other words, in the 40 counties where I've got property, you've gotta go and
Yep.
file a new affidavit. and
But they're generic, so it's gonna just be the affidavit, kinda like the certificate. It's not gonna be addressed to the county. So you're just gonna file 40 of them, just like you would file 40 death certificates.
Yeah, but you are gonna have to file in 40 counties, and then
Yeah.
if there's an operating company, you gotta go to the operating company and say, okay, here's who's in charge of this now. Yeah, so there's a bunch of steps in
Yeah.
40 counties, huh?
there.
You're gonna be busy.
Well-
Somebody's gonna be busy.
It's gonna be easier than while he's doing the deeds now, because the deeds are specific to each county, and so this is just one affidavit that you'll file 40 times.
I got the counties done 2 or 3 months, but changing the oil companies over, I'm still working on that.
But see, that's the kind of thing that your successor trustee is gonna want help with,
Mhm.
so that administrative assistant.
Well, right now, I've pretty much got everything set up to where the bank account's a trust. And so the oil companies, when they get their things going, they write a check to the trust. And it goes to Wells Fargo, and then all you need is some authority to get the money out of that account, and you're on your way.
No, that's a good point. So if there's a way to short circuit that, we would definitely do that. And so if we thought that thing was gonna run okay the way it is, and we could just change the bank account and we could get there, we'd probably do that.
Mhm.
So that's an example where there might be a way of avoiding contacting all of us people.
Yeah.
But sometimes what happens is, that's I just have to think about it. That's the problem with a lot of real estate, especially rural real estate, anywhere, but in Texas, you see it all the time. Mom or dad passed away and no probate was done, right? Well, it's enough of a problem then when the surviving spouse passes away. You know, if somebody's trying to sell the property, well, then we gotta go police up, okay, we gotta show where mom's interest, or dad, the first one to die. So we may either get another probate or what's called an affidavit of heirship to try to get the title sorted out. But if you get a situation where grandmother died and granddad died and nobody
Oh,
probated
no.
anything, boy, there's some of those just can't be fixed. They cannot be fixed.
Yeah.
They cannot sell that property.
Grandpa died in 81, and by about 2015, finally got him out of the way.
Got so many beneficiaries or potentials you can't. No, those are not good.
Do you want to say goodbye to them? Can you you say goodbye so I can turn this off?
Hey, appreciate you joining us this afternoon. I'm gonna say goodbye.